All right, now we're here for intellectual property. That's what we're going to talk about today. It is one of the things I do for a living, along with contracts and corporate work. And I've been a gamer my whole life, and I know you. Come on down and let me make fun of you. No. So yeah, this is a crash course in IP law. If anything you ever wanted to know about IP law, hopefully will be answered today. You will not leave here experts. Please don't ever think you're an expert in intellectual property. You would not, or you probably would believe the arguments I have online with people who think that their Google search is the equivalent of my law degree and 20 years of practice, but hey, if you want to believe fair use is what you think it is, knock yourself out. All right, so that should be 19 now. I've been an audio engineer for a very long time. I've been a performing musician even longer than that, and I work at the Norton Law Firm. I'm a partner there. I also have my own thing I do on the side, but that's not applicable here. All right, here is your disclaimer. I am not your attorney. Do not rely on anything I say to your detriment or otherwise. I'm not licensed to practice in Nevada, New York, or wherever the heck. Actually, I am. We're in Maryland, aren't we? I am licensed in Maryland. Yeah, so I was at Disney all week with my family. I literally flew in an hour ago to BWI, or 2 hours ago, and I'm here. Yay. Slimy salesman pitch. Look, I'm happy to have you as a client. If any of you in here actually need an attorney for contracts, IP, or corporate work, that's fine. Reach out to me. I have clients all over the world, the country, you name it. So why do I do this class? Look, the entire product of the entertainment and gaming industries is intellectual property. That is what you do. Code is intellectual property. A game is intellectual property. A movie, a book, it is all intellectual property, okay? Yeah, that's the answer. So, examples. Movies, music, many other things. And here's another fun one. So, sampling, right? Let's play this.
I give you permission to use this sample.
I give you permission to use this sample.
All right, so the reason that is in there, okay? Occasionally I do live sound for friends' bands. And my friend, his band is a Dune, it's Dune themed, right? So there are no really good samples of Muad'Dib. So he got the entire crowd, and he knew I was recording the show from that night, he got the entire crowd to chant Muad'Dib. It was awesome, it sounded great. And then he turns to me and goes, oh shit, can I use that? I'm like, well, I mean, you don't have everybody's signed release, but I guess, you know, if push came to shove, if we had the entire crowd chant, I give you permission to use this sample, there's not a real argument anybody could make that you don't have permission to use that sample. So that's what we did. We had the entire crowd chant, I give you permission to use this sample. So, and here, let me, now that you have the background, let's listen to that again.
I give you permission to use this sample.
I give you permission to use this sample.
So yeah, there you go. So that's another reason we do this class is there are things that, you know, your attorney can sort of hodgepodge together and teach you about that you might not think about on your own or you might not realize is an intellectual property issue, right? You know, if you're walking around here, you get some really cool samples, you want to use it in your game, you want to use it in your movie or your whatever it is you're doing. Do you have permission to use that? You know, what might what might the institution itself say about you using something you recorded here without permission? Never mind the people that you recorded here, okay? Just, these are things you need to keep in the back of your mind from an intellectual property perspective. So what the hell is it, right? It refers to creations of the mind, like we talked about. Video games, movies, books, they are all things that you create. Things like inventions, literary and artistic works, designs, and symbols, names, and images, and that last tiny little bit at the bottom is going to be a refrain all day, used in commerce, all right? Given the world we live in, the country we live in, the type of economic situation we have, if you do not use something in commerce, if you're not using it to make money or generate revenue, the law doesn't look too kindly at that. You know, if you create something and sit on it and do nothing with it, somebody else could take that. Like the Xerox case, we all remember, you know, no, you don't Xerox something, you photocopy of it. We don't want to lose our name. So, you know, be cognizant of these things. The main forms of IP, it's divided into two main categories. Industrial property, which are things like patents, trademarks, and industrial designs. We're not going to worry about too much about that stuff. We'll talk about trademarks, but we're not going to talk about the other three categories because they're wholly inapplicable to what you do. And the second main form of IP is copyright, and that's what we're going to spend a lot of time talking about today. All right? This covers literary works, novels, poems, and plays, films, music, artistic works, drawings, paintings, photographs, sculptures, and architectural design. So there were a couple of cases in the last decade or so about Frank Lloyd Wright houses that showed up in movies without the owner or Frank Lloyd Wright's estate's permission to do that. So architectural design is copywritten. Rights related to copyright include things like, and here you're going to see a little bit of where the law is archaic, right? Those of performing artists in their performances, producers of phonograms in their recordings. This is actually still the law. Producers of phonograms and broadcasters in their radio and television programs. However, it is usually the stations or the parent entities that own that. No newscasters that I can think of own their own broadcasts, right? It's interesting though, it's the Wild West with regard to live streamers, you know, and all that stuff. It truly is the Wild West. There's all kinds of crazy stuff going on there. All right, so more IP rights. They're just like any other property right, okay? They allow creators and owners of patents, trademarks, copyrighted works to benefit from their own work or their investment in a creation. And we're back to that, again, we'll keep seeing this over and over, this economic component, right? Because I can't go out and market Star Wars. There's no way I can market that movie. I need a company to do that for me, all right? So we assign those rights to a third party, and that third party can recognize the benefit from those creations. All right. So we're going to go through some of the highfalutin, notional, grand ideas about why we do this. Several generally accepted reasons, right? First, the progress and well-being of humanity rests on its capacity to create and invent new works in the areas of technology and culture. Sounds lovely, right? Sounds great. We'll talk a little bit in a minute about why that might not be so. The legal protection of new creations, it encourages the commitment of additional resources for further innovation. That's, again, we're back to that economic, portion of it. And third, the promotion and protection of IP spurs economic growth, creates new jobs and industries, and enhances the quality and enjoyment of life. So these are sort of the notional things behind why we protect intellectual property, all right? An efficient and equitable IP system can help every country around the world and the citizens of those countries realize IP's potential as a catalyst for growth and development and cultural well-being, we hope. The intellectual property system helps strike a balance between the interests of innovators and the public interest, providing an environment in which creativity, I'm going to go blow through these. This is just the boring, dry stuff. All right, so how does this benefit you, right? They reward you for being creative, we hope. That's the whole point of the system, is to reward you for creating something marketable, all right? Examples. The film industry as we know it would not exist. If I could go out and make a movie called Star Wars that had Darth Vader and Luke Skywalker in it, what's to incentivize Lucas, or now Disney, from making more movies, if anybody could just do that? So the movie industry would not exist, right? None of those things. Without the rewards provided by the patent system, researchers and inventors would have little incentive to continue producing better and more efficient products for consumers.
What about artists and artist alleys selling fan art?
No. So look, people hate it when I watch people's heads spin around when I tell them fan art it's a violation, it's a copyright violation. And the fun part about that is, it's not the selling it, it's not how much money you made, it's not if you're donating it to charity. The creation of the work is the infringing act. If I paint Spider-Man and hang it in my bathroom and nobody ever sees it, I have still infringed, well, not Marvel and Disney's rights now. The painting of Spider-Man was the infringing act, okay? Not the selling it or the exhibiting it. So you got to be really, fan art is technically a violation. And
when I was 7 years old drawing Power Rangers.
Yep,
Yeah.
I know, and it's funny, but that's the case. Yeah, go ahead. We're going to have an entire 10 minutes on that later.
Room down there is illegal.
That's not the exact word I'd use, but so my firm is actually the general counsel of MAG. So I'm not going to use that particular word, but a lot of the stuff in Artist Alley is an infringement. And raise your hand if you're a creator. Okay, have you ever exhibited your work somewhere and signed a thing saying, hey, I'm going to vend here? Raise your hand if you've done that. I guarantee you in that document is a clause that says, I will indemnify and defend you if you get sued because I provide any infringing product for sale here. So what that means is, if you're selling in Artist Alley and MAG gets sued by, oh, I don't know, Sony, you got to defend that lawsuit because you promised MAG that everything you sold would not be infringing. So that's why we still see that stuff. The organizations, the entities like MAGFest, you know, all the big conventions, when you sign an agreement to sell in Artist Alley, you're violating it the second you put out a piece of fan art. Anything else? And I'll move on. We'll talk about fan art and fair use in a section in a moment. And this one, by the way, that's what the economic and legal impetus is behind it. I would hope that, you know, helping people not die from diseases is the thing that spurs you to research new and innovative drugs, but the law doesn't really look at that, unfortunately. All right, and here's a good one. Consumers would have very little means to identify and confidently buy products from certain companies. If anybody could just go out there and slap an Apple on the back of a computer, how would you know you're actually getting an Apple? How would you know you're actually getting a Mercedes? How would you know you're going to get, you know, an iPhone, right? This copyright system allows we, consumers, to buy things that we hope should be legitimate, okay? I'm going to blow through patents because it's non-existent unless you are developing some sort of wacky code. Yeah?
So is trademark law then a part of copyright law? Because one of the...
And we'll do that. You ready for this? Trademark or copyright? It's funny. I get this question here all the time. Here's the difference between copyright and trademark. They both offer intellectual property protection. They protect different types of assets, okay? Copyright's geared more towards art, literary artistic works like books, videos, what have you. Trademark protects items that help define a company or brand like its logo, all right? But Mickey Mouse is both. Here's a great way to think about the distinction. Just think about the word, copyright. You have the right to make copies of this thing. I wrote a book, I can make as many copies as I want and sell them. I have a game, I'm responsible for creating this game. I can make as many copies of the game as I want and sell them. Copyright, you have the right to make copies. That's what copyright means, okay? Trademark is just as simple. The mark of your trade, right? The mouse ears, you know when you see the mouse ears, it's a Disney product. When you see the little apple with the bite taken out of it, that's the mark of their trade, okay?
When you first say make a game, is it automatically protected, or do you have to...
So we'll talk about that in a minute too. Trademark's a distinctive sign. Give me a minute and we'll get to that. It'll be a little bit, but. So trademark, distinctive sign that identifies certain goods and services. The origin dates back to ancient times. Craftsmen would actually put their mark on something, you know? You'd buy that special piece of pottery that had the dude's mark on the bottom. I think one of the oldest, and we'll get to it in a second, it's been around for centuries. That's what I was about to say. I'm getting ahead of myself in my own notes. So Roman Empire, swordsmiths in the Roman Empire were the first people to actually use trademarks. They would mark the sword. You knew it was a quality sword if it was made by, you know, Pelagius over there or whatever. Where the hell did that name come? Anyway, all right, some fun background. Nestle's has the first registered trademark in Hong Kong. Avril Paints has the first US registered trademark. And Stella Artois, the beer, they claim continuous use of the mark since 1366. So, I don't know, man. Like, yeah, that's great, but maybe something a little new? Anyway. All right, over the years, these marks have evolved into today's system of trademark registration and protection. It helps you identify the products that you want to buy as identified by their unique trademarks, okay? So what does it do? It ensures that owners of the marks have the exclusive right to use them, right? I can't put an Apple on my computer. I can't put, you know, I can't put a little Mercedes insignia on my car. You know, I don't own those things. They're not my marks. The period of trademark protection varies around the world, but typically trademarks are infinite, all right? And that's the difference between, another difference between trademark and copyright. Marks are infinite, okay? It's legally enforced by courts that in most jurisdictions have the authority to stop trademark infringement. Copyrights expire after a certain time, and we'll talk about that again when we hit the relevant section. So here's a fun one, kind of marks you can register. Any combination of words, letters, and numbers. They can consist of drawings, symbols, three-dimensional signs, like the shape and packaging of goods. Think of the Nike swoosh. Or the racing stripes. Actually, did I put it in here? Let's see if I put it in here. Yes? Oh, I didn't. Damn it. The racing stripes on a Star Wars package, okay? Those racing stripes around the packaging of a Star Wars figure, you cannot package your toys like that. That is look and feel mark. That is a mark that Lucas and now Disney owns, okay? Non-traditional marks are really interesting. In some countries, ours included, holograms, motion, color, or non-visible signs like smell or taste. Think about Nestle's or Hershey. Think about Chanel, right? You can't have something that smells like Chanel No. 5. Trust me, you'd be sued so fast your head will spin. Yeah. Well, hold on, let me get her and then I'll get you.
Is it true that Holly Davidson had to define the signature sound as potato in order to trademark?
I know they have a bunch of marks. I knew it at one point. They probably did. I know Harley's got a very, I believe they have a mark on the sound of the muffler. Yeah. There you go. But yeah, I mean, you know, the Colonel's secret recipe, right? So you could do taste, scent, smell. In a larger sense, they promote initiative and enterprise, yada, yada, yada. We hope that it inhibits the competition, you know, of unfair, we hope it inhibits unfair competition. We want to make sure that if you create something, you're protected and other people can't sell the same thing masquerading as yours, right? Hopefully it enables people with skill and enterprise to produce and market goods and services in the fairest possible conditions, right? And here's where I get to take a break and have a drink, and you will be amused. I like watching the crowd during this one. Make sure you read it.
Copy. Go right, to the right.
It's that law that's the problem.
You know the law.
That stupid law.
What the heck is...
Copy, right?
I'll tell you.
Copy, right?
Is permanently fixed.
The original.
Work. What?
Permanently fixed.
The original.
Work.
In
some form.
That can be seen or heard.
Now listen, this is important.
Only the
Copy.
right
Owner.
Pass the
Right?
to
you
There.
work.
It's mine.
How can that be?
That's not fair.
It's forbidden to
You
copy, right? Work.
Without. Permission granted.
by the
Copy, right?
Owner. And
Anybody who's foolish enough to threaten our
Copy.
right.
Has broken the law.
Aren't we forgetting one teensy-weensy but ever so crucial little tiny detail?
You'd better be able to pay for that.
Copy, right? Permission.
We haven't discussed the subject of payment. You can't get something for nothing, you know.
But I don't have...
I'm not asking much. Just a token, really, a trifle.
Hold on. Back up. Are you saying
This is about
Money.
I'm sorry, sir. I don't have any money.
It's extortion.
I prefer the term capitalist.
Hear that sound? It's the sound of your freedom, fluttering out the window.
So there you go. That is your introduction to copyright. So that's Professor Eric Faden at Bucknell University created that for the EFF, and I love that thing. It makes me just so happy on so many levels. Like, it is the definition of fair use, defining fair use, and it drives Disney's lawyers apoplectic because they can't do anything about it. So it just amuses me. So all right, here, copyright in one slide. It is the exclusive legal right given to an originator or assignee, so either you made it yourself or you assigned it to somebody else, to print, publish, perform, film, record literary, artistic, or musical material, and to authorize others to do the same. That is copyright in one slide. So yeah, somebody had a question? Yeah.
So back to his videos.
Back to the video.
Disney tried to actually get that video removed on that?
Well, I don't know. I can't imagine they would. Just the black eye that they would get trying to get that removed. And so there's some fun stories. Let's take a little diversion here and go down a fun little path. Who has seen the movie the documentary Super Size Me? Anybody? All right. So the investors in that movie required the producer to get a rider on his insurance policy for one thing: a lawsuit by McDonald's. Right? Sure enough, McDonald's sued to have that movie, stopped. And a court decided that documentary filmmaking is, it's almost the definition of fair use. It's a news exception, it's a educational exception. So, but had they not had that rider for a lawsuit by McDonald's, that lawsuit would have bankrupted them. We never would have seen that film, because the entire production budget, everything, would have been spent on defending against that lawsuit. So, as designers of things, as creators, one of the things I want you to keep in mind, and that's why fair use is so dangerous, when you rely on it, it is always a question of law, okay? Even if you feel you have an ironclad exception to somebody else's copyright, which is what fair use is. By the way, when somebody tells you online or whatever that I have a right to fair use, you kind of know they're full of crap from the outset, because that's not what it is. You don't have a right to something. You have an exception to someone else's absolute right to control their copyright, okay? So it's always a question of law, and if you get dragged into court to have to prove it, even if a judge tells you, that's awesome, great, you can go ahead and use this, you have a fair use exception, you've spent $50,000 to $100,000. If it's a major corporation that's litigating with you, you have nothing left. You have no production money left, nothing, and quite frankly, you're probably in debt now. But you had a judge tell you have fair use. Yay. Right? All right. So what does it cover? Novels, poems, plays, advertisements, right? I love seeing old advertisements pop up in people's online little videos that they make for their own advertising. Like, yeah, no, that's not really fair use. Just because it was an advertisement, you can't use it to advertise your product. Computer programs and databases, yes, databases can be copywritten. Films and musical compositions, choreography. This brings up that whole Who's He What's It Dance, Alfonso Ribeiro thing, right? And honestly, it would be the producers of The Fresh Prince that would have the right maybe, but certainly not the actor. But I still, there are some ways in which the United States copyright system is incredibly racist. We can obviously copyright a ballet, a beautiful Eastern European ballet. Okay, why not that dance? Why can't that be copywritten, right? Because it originated with black people in a ghetto. You know what? That's kind of shitty. So, there's a lot of things about our intellectual property system in the United States and really around the world that are not the greatest. And I had someone come up to me before the class and said they wanted to make a game living in Richmond, Virginia, a black woman living in Richmond, Virginia, making a game about the Civil War. And probably that's probably fine from an IP perspective. Those people are long dead, they're in the public domain. But if you're a black woman living in Richmond, Virginia, you have other considerations about making a game about the Civil War and slavery. I don't know if you're going to be safe, and I can't say with certitude that if you made that game, there wouldn't be a problem. But I digress. I'm a bleeding heart liberal, if you couldn't tell. All right. Paintings, drawings, and photographs, sculpture, and architecture, like we talked about earlier, and maps and technical drawings. Yeah, you had a question. You would ask that question. I don't deal in that sorts of things, but my understanding, reading the case law that I've read, is that is the ways of organizing the data. And you're going to cry, but I actually know more about IP than most, or about tech than most attorneys, and I still know fuck all. All right. So the holder of a copyright may authorize or prohibit. Okay, remember this. You can say yes or no. So you can actually let people use your copyright, right, for free if you wanted to. There are a lot of companies that do that. Anybody played Cards Against Humanity? That license is free. You could go out and make a Cards Against Humanity game, an expansion for it, do whatever you want. It's completely free. Dungeons and Dragons, they have the open gaming license. You can go out and make supplements for D&D. Yeah.
Did Tesla do something like that with some of their?
They have with some of their technology, absolutely. And then you have the exact opposite end of the spectrum where, like, what is it, the dude that invented the darkest black ever that prohibited one guy from using it? So I should really throw that in here.
Did you hear about a case about Inktober?
And that's the other way around. Somebody else invented a darker black and prevented that guy from using it, right? Oh, Inktober. I'm sorry, Inktober. Yeah. No, I know all about Inktober. I have tons of clients that are actually participating in it. A lot of my clients are magic card illustrators, board game cover illustrators. So yeah, I think his attorneys were a little overzealous. If you don't know what we're talking about, there's this thing called Inktober. You draw a bunch of drawings all through whatever, and the guy who created it allows you to use the Inktober logo and whatever. And there were some unscrupulous people trying to cash in on it. And the law firm that he hired started sending out a bunch of unwarranted cease and desist letters. And it turned into a big internet scandal. And
So I heard from a couple people, but they came back at Dungeons and Dragons. I heard that they actually made a 3rd edition more public, but then when it came to 5th edition, they made that more prohibitive than using it.
No, I mean, no, it's, the OGL is still there. You can absolutely do supplements. There are certain things you can't do, without their permission. You can't use, like, don't throw Lolth in it, don't throw Tiamat in it, don't throw their big characters. They might have an issue with that, but for the most perspective, the OGL is good to go. I've written modules. So, fun fact about the D&D thing, though, and it's a great example of the holder may authorize or prohibit. Right around the time 5th edition came out, a bunch of Russian language and a bunch of different language editions started showing up on the internet, really prettily bound, and in that language, completely unauthorized. So if you're going to translate somebody else's work into another language, you better make sure you license it first. Don't just think, oh well, they're not going to do this, so I'm going to do it myself and provide it. No, that's a real bad idea. Yeah. Yeah, you're looking at one. No, I mean, lawyers are a great way to start. You can look in the USPTO, see who's got trademarks on things, the Copyright Office, you can see who holds the copyright on things. Honestly, if you're looking for properties that are already out there, you're going to laugh, but your best bet is IMDb Pro and see who their agent is, right? I mean, it's funny, but I actually use it for my art clients who want to, paint a picture of X, or they want to use this, whatever this IP is, and they want to use it in their product. IMDb is a great place to go to find it, because you find out, because the movie's usually the biggest property. It doesn't really, other than Star Wars, by the way. Star Wars is a toy franchise, not a movie franchise. But anyway, just go to IMDb and you'll find everything you need almost. Yeah.
So where do YouTube Let's Play channels fall on the scale of things?
So they're traditionally being considered fair use because you're showing people what it is, you're reacting to it, you're informing the public about certain things. I think that's a generous position. Most of them haven't been litigated. I can't think of one that's been litigated. Okay. And remember though, seriously, YouTube is not a government. They're a corporation, and you put things there at their sufferance. So whether, until that stuff starts not being revenue generating for YouTube, it's probably going to stay there. I mean, YouTube has no interest whatsoever in helping you as a... What's that?
Nintendo put copyright claims on every one of my Mario videos.
I mean, you know, unless you're making tons of money for YouTube, they have no vested interest in helping you stop that. Sorry, the comment was Nintendo put copyright infringement claims on all of his Let's Play videos. Mario Kart? Super Mario, right? So, yeah, I mean, look, you've got... It's not a strike, but it's a claim. I know. You've got this huge entity that another huge entity is saying, hey, you're screwing with me, and you've got you, the nobody down here in the middle. You're not going to win that. There's nothing to win. There's no fight to even be had there. I'm dead serious. So just smile, nod, and... I mean, realistically, right, would you hire someone like me at $350 to $1,000 an hour to fight that? Right. Just go play something else. Yeah.
What do you do if, like, say someone steals your work in another country and sells it?
So that's rough. I mean, so there are certain, sorry, the question is, what do you do if someone steals your work from another country? Okay. US, UK, European Union, well, who knows how that whole Brexit thing is going to work out. So, you know, stuff registered in the EU might not be registered in the UK now. But, and Canada and Japan are usually the ones that I recommend my clients protect in. Realistically, let's just back up for a second, right? Somebody in India is infringing your copyright. Okay, you're going to hire an Indian law firm. You're going to try to litigate over there against laws that are probably not favorable to you. I mean, you're looking at $100,000 just to get the ball rolling, right? Like, what do you do? Here's a fun story, and this will sort of illustrate to you the magnitude of the problem of copyright infringement. So one of my clients runs a Harry Potter convention, right? And they got a cease and desist from Universal. That's Universal, right? Universal owns, yeah. And we had a lovely chat with the attorney on the other side where their contention was they had copyright over every expression of the word Potter as it relates to magic. I had a nice chuckle and we had a lovely conversation. You know, and I admitted, hey, my clients might have ripped off that font and they'll be changing that immediately. That Harry Potter font is copywritten. You can't use that, right? It's the movie font. It might be available online, but you know, it was worth every penny you paid for it, which was probably free. So we had a lovely conversation. They would change the font. And at the end of the call, I congratulated her on the Harry Potter pop-up bar that was about to open in DC in a few weeks. And you could hear her sigh of long suffering through the phone when she said, can you send me that link, please? So it's not just you guys, the small creators. It's big, huge companies that have their IP infringed constantly. So they play IP whack-a-mole in the same way that we all do. So hopefully that fills you, that gives you some small sense of schadenfreude, which, you know, delight in the misery of others. Yes?
So you might get to this later on, but could you talk a little bit, like you're getting your friend intellectual property and you love it so much. What are the procedural steps or checklists that you would suggest a creator go through in order to...
Sure, no, it's not something I go into, so I'll happily answer it now. The question is, what are the steps to go through when you've created a new intellectual property piece? Like, whether it's, she asked about a game, but whether it's a game, a book, a board game, a movie, whatever, right? So let me be clear. Copyright affixes to you the moment you set something in a tangible medium. So, and that tangible medium could be your computer. The second you write it down, the book you've written on your computer is copyright you. The problem is you cannot enforce that until you file it. And if somebody else files that before you, you're in a little bit of trouble. Now you're in litigation. So copyright affixes to you, but the first thing you want to do is, once you're done, file it with the Copyright Office, okay? And it's funny, I'm a huge Magic the Gathering player, right? So there are people that sit out there and camp on the trademark, trademark website, and as soon as Wizards of the Coast files a new trademark, we know what the next expansion is going to be. We know what the name of that expansion is going to be because they filed a mark on it. Right? And I mean, that's how it works. So if you've got a huge property that releases constant updates, then yeah, you're going to be, you know, that's going to be your leak. I mean, if you're good at your marketing, you're going to get out in front of it, but otherwise, you know, that's your leak. So that's step one is it's copywritten when it's written. You copyright it. You trademark it if it's a completely new IP, right? Like, I don't know, I wrote a new book and, you know, I want to mark the Name of the ship. I want to, trust me, I want to trademark the name Firefly, right? I want to trademark the name Millennium Falcon. It's not just a copyright. That's a mark of my trade. That's a really important part of my IP, right? And then you start getting into, well, do I want to do this outside the United States, right? What makes sense for you? If your game or your book or whatever your product, if you think it's going to sell well in the EU, do an EU IP filing. They're not that expensive. I mean, I don't know what dollar amount we're talking about here. I mean, if you're looking at 20,000 in revenue, it might not make sense. If you're looking at 200,000 in revenue, yeah, it makes sense, right? And then I also recommend UK, Canada, and Japan. But realistically, you're not going to litigate in Kazakhstan. You're not going to litigate in Russia. You're not going to litigate in China. Don't even worry about it. You're going to get ripped off in those places. Just live with it. My wife and I make independent films. Anybody like D&D? We did Eye of the Beholder, The Art of Dungeons & Dragons. That's my film. So if you like D&D and you've seen that film, Merry Christmas. But that film was on Pirate Bay before I got the first pressing back from Discmaker. So it's just going to happen. And our distributor laughs at us. They're like, oh yeah, it happens with everything. Like, don't worry about it. They were never going to buy your movie anyway. And it's true. I mean, people who are going to pirate it are never going to buy your movie anyway, or your product or your game. They're going to pirate it. So don't waste your mental energy and your money. And trust me, you're not going to be able to litigate with somebody in China or Russia, or it's just useless. So I wouldn't even recommend trying to protect it there. So all right, yeah, go ahead.
I have a question. A few minutes ago, you mentioned in connection with Dungeons and Dragons, you mentioned Tiamat, but Tiamat is a.
It's a Greek god. That was a bad example. That's my fault. Tiamat's a Greek god. You could actually probably do something with Tiamat. Sorry, yeah, Babylonian.
Things that are from older than copyright, like could you just copyright, like for example, Zeus?
You could try, but no. I mean, Disney has copyright on the particular expression of Zeus, like the character. But you can draw Zeus yourself as long as it doesn't look just like the Disney character. Yeah, and I mean, public domain. Let me just, I'll flip forward ahead here and we'll talk about this because that's actually something I really want to talk about. Obviously, I'll take a second here on assignment. I'll get to your question in a minute. Look, we can't afford to, I can't afford to market my movie. I had to get another company to do it, right? Lucas hires companies, pays millions of dollars, well now Disney. Lucas hired third-party companies to market his movies. You can't do it yourself. So creators assign these rights to companies that are better situated, right? I mean, think about all the game designers that are basically sub to other companies. Like Square Enix doesn't make everything, or well, maybe they do, but every game company doesn't make everything themselves. They farm it out to other development houses. And you can't do everything yourself. Limits, and this is where I wanted to be. So it gives copyright holders rights for a limited time as an incentive to create these works in exchange for it's basically a limited monopoly, right? When you do something, the copyright's yours, it's a monopoly for all intents and purposes. And we'll talk about fair use, which are the exceptions here, right? It does not give copyright holders total control, all right? They transition to the public domain and become available for use by the public when the copyright term expires. So in the US, anything created after 2002 expires 70 years after the death of the author, okay? There it is. If the work is of corporate authorship, however, the term expires 95 years from publication or 120 years from creation, whichever expires first. So let's see, the character Ray came out, 6 years ago, 7 years ago now, whatever. So the character Ray will be public domain in 112 years, which is ridiculous, obviously. On its face, it's ridiculous, right? Needless to say, there's a whole host of arguments against these terms. I mean, look, these lengthy terms appear on their face to contravene the law's intent to incentivize and benefit society as a whole. You know, a 100-year monopoly might be excessive and contributory only to the benefit of Disney. Disney, by the way, is one of the devils. The copyright term we have now is because the mouse is about to expire, and the mouse is about to expire in 2020, I believe. And mark my words, I'll give this speech again in 2 years or 3 years, and we'll have a chat and we'll see if copyright term has not been extended. mean, they can't lose the mouse. That would be obscene for them.
But I mean, the mouse is a trademark. They can't lose the mouse.
Right, but people could start making mouse movies. And that's a problem for them, right? That's a huge problem for Disney. All right, here's some exceptions. Face-to-face instruction, virtual instruction, fair use. Fair use is the big one we'll talk about. You know, obviously, I can throw things up here, face-to-face instruction. I can put examples up here because I'm teaching you what things are. I'm not infringing because I have an exception. I'm teaching. And here's fair use. It is a limitation or exception of the rights granted to a copyright holder. All right? It allows someone other than the holder to copy all or some of the work, even if the copyright holder has not or refuses to give permission. There are Weird Al songs. He doesn't have to get permission, but there are Weird Al songs we will never hear because the copyright holder refused to give permission. That's Al's particular code, and you know, more power to him, but he could have published those songs. That's the reason I mention it. Those songs could certainly be out here. They're parody. They're intended to be parody. Sorry, I skipped over your question. So give me a second while I ask your question. I'm going to take a drink of water.
Okay. So I was actually going to ask about parody.
Okay.
So, what are the boundaries of that? So, and are there limitations at all? Because, for example, one of the big things on YouTube is that people make use of memes in their videos all the time.
So what are the exceptions to fair use or to copyright? We're going to talk about all this stuff, by the way, in the next 2 slides. So memes, I'm probably in the minority. I don't think memes are actually parody or satire. I don't believe memes should be given fair use protection. There are a lot of people out there. I mean, the guy walking down the street, looking behind him, right? He should have been compensated for that. That thing's everywhere. The European Union, by the way, is considering changing the way how all that works. And you post a meme that's not yours, you need to be paying them. It's going to be a really interesting time to be an IP attorney in the next couple of years. All right, so why do we do this? It carves out a space for creative uses of music, literature, movies during the period that the work is otherwise protected, right? It's helped to reduce, if not relieve, the tensions between copyright law and the First Amendment's guarantee of freedom of expression. Think about political cartoons. Those are the best example. I mean, you know, political cartoons are great. They are the utmost in satire and parody. This is my favorite piece of language. It is the guarantee of breathing space for new expression within the confines of copyright law. And here's how a court decides whether something is fair use or not. Before I get into this, by the way, just a show of hands. How many people have posted something or used something in a piece of art or creative thing that they found online? All right. Did you have a license for that? Did you? And you would not believe the people that ask me, well, I found it on DeviantArt and I couldn't find out who owned it, so I could use that skin in my game, right? I can use that I can use that to cover my building or my space background. No, you've stolen somebody's art, and you should probably find out who that is and compensate them. Yeah.
How do you know the copy wrote it and what if it's an orphan work?
So, look, orphan work is a weird misnomer, right? I mean, somebody created it, obviously. And orphan work, well, you know, you got to track down the earliest use of it and then wait until it's in the public domain. That would be my advice as your counsel. If you can't figure out who owns it, you have 2 choices. You use it knowing it's a potential risk, and you have to tell. So here's a fun story. Anybody made a movie here? Even an indie film? Whatever. If you go to get it distributed, you have to fill out what's called a fair use, or an IP spreadsheet. And for every second that's on the screen, you have to fill out the spreadsheet that explains, this is what's being shown. I have a license to everything in that frame. This is the music that's playing. I have a license to every music. And you have to do that because your distributor, whoever's buying it, requires E&O insurance. You're doing it for your insurance company, okay? And if you're a game studio, you are going to be doing one of these sheets for every frame in your game, okay? You're going to be explaining to them, here is what's on screen. Here's who made it. Here's the license that assigned that to me. Here's the music that's playing in the background. Here is the license that I have for that music. If you can't do that, or if you lie on the spreadsheet that you're filling out for your E&O insurance, not only are you in trouble from a risk perspective, but congratulations, you've just committed insurance fraud. So, yeah.
Okay, so I'm an author.
Okay.
And my friends and I write together, and we are thinking of promoting on social media.
Okay.
And for that, there would be some pictures involved. Do those have to be protected, or because it's out on social media?
No, I mean, they're yours. The second you take that picture, and if you take the picture and you're the one in them, they're yours. I mean.
But say it were just a generic picture, a background picture, even though it's used for social media, it's also used for promotion.
What is the generic background picture of?
But just say, say we wanted to do something celebratory, so we did like a picture of confetti that we found on the internet. But we're not promoting, like we're not selling anything.
Doesn't matter. Okay, so the question is, if they wanted to promote their work and they found a picture of confetti on the internet and they used it as a background with some people in front of it or whatever, no, that picture of confetti is somebody's intellectual property. And you never know, like they might have a watermark hidden in it somewhere, there could be some digital identifier. There's this dude who runs a Shopify, like how to build your Shopify shop. And he's since taken it down, but he did a 5-minute diatribe on these unscrupulous artists that, all they do is they troll the internet looking for people that might have innocently used one of their images. And I mean, baseball hat backwards, the picture of a douche bro, sorry, and I'm just watching it going, you're offended because you stole something? Okay.
That's very useful to know.
Yeah, I mean, look, just think about it this way. If you walk into a physical store and there's even if it's a little piece of paper with something on it, you can't take it, you gotta pay for it, right? So it's the same with stuff you find online. Yeah.
If I find something on a site marked as public domain and they in fact stole it from somebody else.
Yeah, you're on the hook too. So the question is, if I find something that's on a website marked fair use or public use or free, free license, whatever, OGL, who knows, or it's new public license, whatever version, do your homework, find out if it really is. Because a lot of stuff posted on those websites was stolen from somewhere else. And all they want is the ad revenue from you coming to their site and clicking on whatever it is you want for free. Yeah, and then I'll get back to you.
So just to say it out loud, stock photo website memberships are actually like stupid cheap. So
Yeah. Stock photo websites are stupid cheap. I mean, literally some of them are like, $9.99 a month and you can cancel after a certain amount of time. Just go there and get what you need and let them bear the risk for that. And make it be a reputable company like Getty or, there are reputable companies out there. Unless, of course, you've made, Old Town Road, and in which case you get to give Trent Reznor a country music award. Sorry. If you don't know what I'm talking about, ask me later. Oh, hold on for a second. Let me get that question, and I'll come back up here. In the back, yeah.
So it used to be that Google Photos, you could type in Google/free domain when you were looking for images, but recently that's kind of changed that.
They don't want to bear the risk.
Does that mean if you're looking for an image and you even use the free domain, that those images are also subject to copyright now?
Well, you don't know. So the question is about Google/free domain and whether, do you trust Google? Because I sure don't. I'm dead serious. I mean, sorry, but the amount of data that they're selling is astronomical, and the amount of data they're collecting is astronomical. But that said, I would not trust that. I mean, unless I had a company. If you go to one of those reputable sites, like a Getty Images or whatever whatever the heck they are now. My wife's the editor; she does all that. But they're stupid cheap, and I've read all the license agreements because obviously I have to stand behind the things I put in my movie. So if we use, I need an overhead shot of a river, well, I need to make sure that I can use that in my film or whatever it is I'm doing, or my game or whatever. So they're going to bear the risk for that, and they're going to be the ones that have to defend me if I get sued because I bought it from them. And that's the real reason you want to pay for stuff. Like, if you take nothing else from this discussion, it is whatever you find for free on the internet is worth exactly what you paid for it. Nothing, yeah. Yes?
What if you want to take a picture of, like, Niagara Falls or something, and it's, a known location where
You're probably okay with Niagara Falls, but like, I don't know, certain cities, like if you take a picture in New York City of the Empire State Building, you better be licensed by the New York State Film Board. I can't film there without that license. If that shows up in my film, I'm going to get sued by the city of New York. So be really careful about that stuff. A lot of locations and locales, if you're shooting in public, images, moving footage, like, you know, whether it's stills or not, or you want to use it in your game, you can use a location probably, but, oh, tons of questions. All right, you first.
Is that why a lot of commercials or like the movies and stuff, they'll censor or blur out license plates?
Yeah, that's exactly it. I mean, that's why I have to be the IP Nazi on my sets. Like if, you know, if there's a Mercedes driving by, I got to make sure that that Mercedes symbol is not in the shot, because I don't have a license from Mercedes to have that in my product. If you're making a game, please do not put a Lexus in your game without a license from that company. You know? Yep. And then I'll come back to you. No, go ahead and then I'll.
So, tap on to what she said or what you were talking about. I think there's a thing with the Eiffel Tower, depending on whether it has its lights on or lights off.
Oh, you better have a license from the government of France, no matter what you do with it. You can take your own private pictures, but if you try to sell something with that in it, you're going to get a cease and desist. I think last year there were like 79 letters that they sent out to major production companies. Yeah.
If you get a picture from Google and you just sort of young recognition for a picture, is that allowed?
I'd say that probably fits under one of these things. So look, you have mangled it so much that it's unrecognizable at that point, so who cares what it is? And from a legal perspective, you know, as if I were your attorney, I would say, look, my job is to manage your risk. And your risk here is you've mangled it so much, nobody, the owner couldn't possibly know what it is, so have fun, go to town. And that comes to you. You asked me a question earlier about that, right? So how much is too much, right? I love it when artists go, well, yeah, but if I change it 7%, it's fair use. Really? How did I change a picture of Spider-Man by 7%? You know, can I reach into the cash register and take 7% of the earnings? Or, oh, this one makes me want to shoot people. I heard my film school professor told me I could use 7 seconds of a song without paying for it. No. Sorry, if you use a piece of music in your game, you better have paid for it, no matter how little you use. Yeah?
So a lot of professional artists working for games will just go onto Google and take a random photo and then use it for like photo bashing in their artwork. And I've always wondered, and sometimes if you can tell what photo it is too.
Look, if you could tell what photo, sorry, the question is, you know, is it kosher, right? The question is, can I be doing this? If you're taking anything you find on Google or any web search and using it in something, if it is not 100% unrecognizable, odds are good someone's going to see it one day and you might get a letter saying, hey, you know, you owe me some revenue for that use of my image.
Even like really big companies are doing this and they don't seem, like they never seem to track or do that.
That's a problem. They're exposing themselves to risk. I mean, if big companies are doing it, it's a problem. You know, and I submit that that was probably something that was farmed out to a contractor and might not have gone through the final review it should have. You know, God forbid a game designer should sneak something into a game. Yeah.
So you mentioned before you started the talk that this is a whole other topic, but I think a common theme that a lot of people deal with is collaboration.
Sure.
People come together to work on a project with resources produced, and then that relationship dissolves.
All right, I'll talk that through from beginning to end. All right, so the question is collaboration. You come together, you make some stuff, and then it falls apart. Who owns the stuff? What do you do with it? So, good God. That's literally a 2-hour class. But in a nutshell, form an LLC, have an operating agreement for that LLC, and in that operating agreement, you're going to explain who gets what cut of what, how people are going to get paid, what's going to happen if this company goes under. Whenever I'm forming a corporation or an LLC for someone, one of the questions that is really uncomfortable for people, not for me because I've asked it so many times, but what happens if your partners are stealing? What happens if one of your partners goes to jail? What happens if one of your partners has a mental illness? What happens if one of your partners gets Alzheimer's? And I submit to you that if you can't have that discussion with someone you're going into business with or building a piece of intellectual property with, you should not be in business with that person. If that question is too uncomfortable, you're going to be spending like 50, 60 hours a week with this person. If you can't have that conversation with them, you should not be in business with them. You should not be creating together. if that's too uncomfortable. Because at the end of the day, this is a business. You want to have a business making your art, right? And we would call it the entertainment fun if it were, it's the entertainment industry. It's the entertainment business. It is not the entertainment fun, although it can be, right? You gotta think about business things. You cannot, another class I really should do for MAG, and it's gonna take me a whole day if I did everything I wanted to do for MAG, but I wanna do how to start your own creative business and how not to, get yourself screwed over. But seriously, form an LLC, right? Have a good operating agreement and understand what's gonna happen to the IP if something happens. And the other thing I would do is actually get a corporate insurance policy. Make sure you get a corporate insurance policy for the company. As long as you're acting in good faith, you don't intentionally rip off someone's IP or intentionally engage in wrongdoing, you're gonna be personally covered for anything that entity does. Okay? Yeah, question in the back.
My brother used to work at DreamWorks, and when he was hired, he had to sign an ownership of intellectual property agreement where anything that he created while he worked.
An assignment form.
Yeah, was DreamWorks. And I want to understand, is this common with big gaming studios?
It's common with every corporation in any way involved in tech. So whether it's a gaming, the question is, her brother used to work for DreamWorks, had to sign an assignment agreement indicating that all intellectual property created while he was there was the property of DreamWorks. And the answer to that is, it is across the board. If you're involved in tech in any way, government contracting, game creation, whatever it is, you're gonna sign that document or they're not gonna hire you.
And my understanding was, this was in his personal life.
Yeah, some of those are unenforceable depending on the state you live in. Usually non-disclosure, non-competition, and assignment agreements, it's got to be limited by geographic location, time, and industry, right? So if I say I live in DC and I work for a big government contractor, they can't tell me I can't work for any government contractor forever. But they can say I cannot work for any government contractor for 1 year within 25 miles of their main office, and I can't have any of the current clients. That's been upheld pretty regularly. California is really good about making sure that stuff you do in your off time is yours, as long as you don't use company resources. There's a whole episode of Silicon Valley about this. You had a question, and then I'll come back to you. Yeah. Yeah.
Okay. Sorry, this is a quick side. You didn't mention your name at the beginning of the panel.
Oh, sorry. My name is Seth Polanski. I'm just a dude. Yeah. I've been doing this for a while. Sorry. I want to get right to the meat of it. And there'll be a slide at the end. You had one up here, right? Yeah.
I was wondering, so you said that they can limit, like, with regards to a location. Doesn't it have to be limited to a location?
Usually, yeah. I mean, if you tell somebody they can't work in an industry, even if it's 1 year, you can't tell somebody they can't work in an industry for a year. They have to have the right to make a living. You can't, and it's awful. Well, it's good for me as an attorney, but I cannot be bound by one because you cannot stop people from choosing the attorney they want, right? So that's an unreasonable restriction on people's ability to choose their attorney. Anyway, at least in Maryland. Yeah.
How about transformative works?
All right, so let's get back to this. So what time is it anyway? Am I supposed to be? I got 3 minutes, huh? All right. Let's go to transformative. Here we go. So fair use in one slide. Purpose and character of use of the copyrighted work. And that's broken down into two things. Transformative quality and whether it's commercial or non-commercial. So that's the first pillar of whether something is a fair use or not. Then there's the nature and use, the amount and substantiality, and the effect on the potential market. So common fair uses, here I'm blowing through this. Parody or satire, news, education, public figure. All right, purpose and character. Transformative quality and commerciality. Here's transformative quality. Did you actually transform it in a new and different way? This is where most of you creatives fall down, right? Just because you put a stormtrooper on a thing saying, I want you for the Imperial Navy, sorry, that's not transformative. It's cute, but you haven't commented on society, you haven't made a philosophical statement, a social statement, you've done nothing except steal a stormtrooper. right? And Disney's probably not going to have a good time with you with that. Here's a good example, using Google, of course, right? Google was sued because they made thumbnails of images from Getty. Think about that, right? Getty sued them because Google was making thumbnails of their images that linked to the Getty images for people to buy. You know, and the court said, idiots, this is highly transformative, and Google's actually helping people buy your stuff. So that's a good example of transformative from a technical perspective. This one, I have some problems with because I don't think it's transformative. It is a way in which wealthy white people can make an argument before the Supreme Court that not wealthy people of color or anyone else cannot make. Oh, where is it? Damn it, I didn't put it in there. It's Jeff Koons. Basically, it's literally a picture of Gucci sandals and donuts. It's ridiculous. I'll find it at the end. Commercial, non-commercial. Will you make money from the new work? Remember, even if you gave it away for free, you're still infringing, okay? Remember that. Even if you make something that's infringing and you give it away for free, sorry. Yeah?
Is that because the original copyright holder is losing money then?
It has nothing to do with it, seriously. Not this particular pillar, it is in the next one, but it doesn't matter, right? You'll see what I mean. Here we go. Let me get through that. Nature and use. Particular use is more likely to be considered fair when the copyright is factual rather than creative. Amount and substantiality. So this gets to that question. Look, if I make a movie that has a Death Star in it and a force in it, I've probably copied a little too much, right? How much is too much depends on the purpose for which the work is intended. Parodies need to make extensive use. Robin Hood Men in Tights, Spaceballs, right? If you don't use the Schwartz and lightsabers and what, Spaceballs needs to make extensive use. And by the way, this goes to another fun anecdote. Lucas and Brooks had a meeting, and there's a scene that tells what this meeting was about. And Brooks said, "Can I make this movie?" And Lucas said, "Absolutely, go ahead, go have fun, make it. No toys." And of course, in the movie, there's a scene where, yeah, get them here because you can't get them anywhere else. And there were no toys made from Spaceballs. So, yeah. I know, I got to wrap up. I hate Scientologists, so this is making fun of Scientology. Yeah, they literally sued the Washington Post because the Post published a tiny bit of their available online pamphlets. Yeah, and the court said, no, sorry, it was a small purpose, and there was a news exception here. This gets to your last question, then I'll wrap it up. Look, the effect on the market, right? Even if the original work is given away for free, never mind the new one, even if the original one is given away for free, if you use the work in a way that takes market share away from the copyright holder, that is going to weigh against you for fair use perspective. The best example here is Andy Warhol's Campbell's soup cans. No one is going to walk into a grocery store hungry and walk out with Andy Warhol's Campbell soup can painting. There is no market dilution there on either side. It's a great example of market share. And I think, last, I want to go through all of these because they're fun. The Family Guy made fun of the Carol Burnett Show. No one is going to go looking for an episode of the Carol Burnett Show and mistakenly buy Family Guy, right? So here's the end. Warning, these are guidelines, they're not exclusive. Courts are most interested in whether you've acted in good faith or not. Did you seek the permission of the holder? And are you actual scientists or creatives acting for the good of humanity, or are you just business people looking to cash in on somebody else's IP? And I'm not going to talk about The Wind on Gone, which is literally Gone with the Wind from the slave's perspective, scene for scene. There was a huge issue kerfluffle about it. And I don't have time to talk about it. So look, fair use is always a question of law. Even if you feel you have an airtight case, you could still be dragged into court, which is expensive. And you'll have distributor issues with your game or your movie or whatever it is you're going to do. All right? I think that's it other than that. And I don't have time for questions. I'm sorry. I will stick around in the hall if folks want to chat. Yeah, come and get a business card if you want to have a copy of the slide deck.